Hello, Fresno. This is MJ Borelli here, and welcome to another episode of Fair Housing, It's the Law. I'm with the Fair Housing Council of Central California, and we are advocates for anyone who's a home seeker or a tenant. Um, of the many areas that we have covered, which have largely been about housing discrimination, there's another scourge upon us that is called bad landlording, otherwise known as slumlording. Lots of different names for landlords who refuse to make repairs or provide an adequate housing situation for their tenants. Now, in California, where we all are, landlords, when they rent or lease a place to live, do so with an implied warranty of habitability, and that's California state law. And to talk about some of the things that happen to bad landlords, or some of the things that bad landlords do, I have Margaret Elder, an attorney with a firm, Elder and Spencer, LLP, and we're going to talk about what happens to you if you're a slumlord. And so if you're tuning in and you have rental properties and you haven't been taking care of them, you might want to take note. Margaret, tell us all about yourself and what you do.
Sure. My name is Margaret Elder. I'm a partner at Elder and Spencer. We practice in the entire state of California, from the Oregon border to the Mexican border. Our firm is dedicated to housing rights. We file cases for housing discrimination, for habitability, for harassment, for wrongful eviction, constructive eviction, anything that has to do with protecting housing rights for renters, our firm handles. We have a fairly large presence here in Fresno, and we've been here for about, I would say, almost 10 years. And in fact, my very first case in Fresno was a case that I handled with MJ. It was a housing discrimination case. But so what our firm does is we sue bad landlords, particularly bad corporate landlords who have a business model of slumlording and not taking care of their property and taking advantage of people who a lot of times have single mothers who with children, disabled folks, people that for whatever reason don't have the means to leave. And so our firm comes in, we sue the landlord, we hopefully get the property fixed, although that's depends on where we're at, how successful we are on making the landlord do repairs. I tell tenants all the time, I can make them pay money. I can't make them fix your place, unfortunately. That's a government proceeding. So that's what we do in a nutshell, is we sue bad landlords. And we're good at it.
They are good at it. And I think when you're busy all the time in trial with these guys, that's proof in the pudding. One of the things that we find at the Fair Housing Council, most of the folks that contact us have housing discrimination complaints. But on the flip side of that, 9 times out of 10, they also have landlords who are errant in making repairs, or they have apartments or other rentals houses that are overrun with vermin like mice, rats, roaches, that kind of thing. And I don't think there's a day that goes by that I don't talk to a person in our area of California, Central California, that doesn't have a complaint about a landlord who really is in violation of that implied warranty of habitability. Let's talk a little bit about what does that mean exactly.
Sure. So the warranty of habitability is actually can be imposed 3 different ways. There's the implied warranty of habitability, meaning that implied in a contract is that the unit's going to be habitable. And then we also have a California statute that says the landlord shall keep the property in these minimum standards, and that's backed up by the Health and Safety Code. and usually Fresno Municipal Code has habitability requirements as well. So we have the implied in the contract, the rental agreement, that's the contract. We have the statutory implied warranty of habitability, the law. And then we also have, in California, we have pretty good renters' rights here. So we have a tort claim for the breach of the warranty of habitability. So if a landlord breaches the warranty of habitability, they can come at you in three different angles, right? Statutory, and that's where the code enforcement comes in, and they'll cite the landlord for violating this housing statute, right? But then we also have the civil code that says you're civilly liable, landlord, if you don't, to the tenant, if you don't maintain the unit in minimum standards. Then we can go on the rental agreement, and there's an implied warranty of habitability even in an oral contract. It doesn't have to be a written rental agreement. It can be an oral agreement that the thing that you're contracting for is habitable, or it's fit for the purpose the purpose of the contract. And then we also can go tort, which is in California we have Green versus Superior Court was a seminal case in habitability, and then Stoiber versus Honeychuck has followed that says, wait a second, you can get personal injury claims for the breach of the warranty of habitability. So hard to say, a mouthful. But so the landlord can be liable for the emotional distress a tenant incurs because of the uninhabitable condition, and any physical injury that the tenant incurs. So if a bed bug bites them, they have an allergy to cockroaches, they have trouble breathing, they can't sleep, they God forbid, we've had cases where the ceiling has collapsed on someone taking a shower. All of those things the landlord is responsible for. Even if the landlord wasn't there and the manager fixed it, the landlord is still responsible. At the end of the day, the person who owns the property is responsible for what happens on their property. So that's three ways that we come at a landlord for the breach of the warranty of habitability. But then there's also the breach of the covenant of quiet enjoyment, which is implied in contract and statute, that if you're entitled to enjoy your surroundings, and if you have the landlord coming into your apartment harassing you, it's not fit for the purpose of living there, then the landlord has also breached the covenant of quiet enjoyment, which is also a covenant in that contract. So, and then of course we also sue for negligence. Because the landlord was most likely negligent in the management and hiring of their people and in the maintenance of their property. We also can file a claim for a nuisance, both public and private. So if you're a tenant and you have a unit that is infested with cockroaches, that could be also a public nuisance. We've had cases where our clients have been fired from their jobs because maybe they were a housekeeper or something, and they go to work and a cockroach comes out of their backpack or their bag or something, or they're food service workers, and so it becomes really this small isolated problem in an apartment complex can affect a whole community, particularly with bed bugs and those types of vermin that are carried on your person, and you go from place to place. And you go on public transportation, you have bed bugs, you have cockroaches, and the next person sits there, they pick up a bed bug or a cockroach. And so we do sue for nuisance as well when we file lawsuits. And if it's really bad, we sue for punitive damages. So if we have a landlord that is knowing and willful in the refusal to repair a building, we also add punitive damages. And what punitive damages are, it goes after the wealth of the landlord, right? So it's a punishment, right? Punitive punishment for the behavior that they've engaged in that caused harm to their tenant. So there's lots of remedies available for tenants in California for bad landlords, and unfortunately, we're a very, very busy practice.
It seems to me that a lot of these types of claims and a lot of complaints that I hear at the Fair Housing Council are, generally speaking, they're coming from people that have very fixed incomes. For the most part, they're poor people. Not all. You don't have to be destitute to file one of these claims. But it seems that there are a lot of aging properties in our area. Aging properties, apartment complexes, duplexes, that are kind of, I see them marketed on the internet as white elephant properties that you could conceivably fix up, which they don't. They might slap a little paint and purchase them. And I hear from these folks these kinds of troubles. Those aging properties where you haven't addressed any of the infrastructure of the property, maybe just slapped on a little paint around the baseboard.
We call it magic paint.
Magic paint indeed. And in fact, I had a call like this yesterday from a gal who was living in a complex known to me that I know was developed in the 1970s in a part of town in Fresno, which was developed for a huge internal revenue service center in southeast Fresno. And that center has been closed now for, 7 years. And the properties are still there. A lot of them are have vacancies, and they tend to be not cheap, but they tend to be the lower rate. And this is why people move into them. They're a little bit more affordable. That's unfortunate that if you're looking for an affordable place to live, notwithstanding we've done many programs on this so-called affordable housing starts that our state and local governments are touting, which really aren't affordable, but that's another issue. This is where people go. And one of the things that we find in fair housing is the folks that wind up renting these places tend to be those folks that we consider to be members of protected classes. They tend to be people of color. They tend to be disabled people who are maybe living on a fixed income of Social Security disability, for example. So these kinds of landlords in their practices, in and of themselves have a disparate impact on these protected classes. So there are also some housing discrimination elements to some of these claims. Now, what do people do when they have a situation like this? Now, I also run into folks, we're an agricultural valley, so we have a lot of migrant workers or people who are in the agricultural industry doing agricultural labor, and a lot of times they have situations with their immigration status that makes them afraid to make a claim against a landlord. I don't know that I don't think it matters what your immigration status is in terms of making a claim like this, or does it?
It does not. It does not. And you hit the nail on the head. I got my start as a legal intern at the Fair Housing Council of Orange County. And then I became, when I got my bar card, I loved it so much, I stayed there, and I was a staff attorney there for 5 years until my daycare costs exceeded my salary, and
Right.
I had to move on. So, but when I was there, part of my job was preparing cases. We didn't file in-house. We sent those out to Chris, actually, to file in federal court. But I gathered the evidence and what have you. But one of my main functions was to defend tenants and unlawful detainers, particularly tenants who were members of a protected class. And so I started noticing 30 years ago, like the correlation between protected class and substandard housing. And so I started calling slumlords reverse discriminators, because they would actually market to disabled people to people that were not documented, to single mothers. And the reason they do that is because they have no voice. They want tenants who don't have a voice. And so people that are disabled tend to pick their housing based on public transportation, based on caregivers, based on their healthcare providers. And it's devastating. A lot of them are on disability or very, very fixed incomes. And they get into a unit that's, inexpensive. And, it looks like it's got magic paint. They don't see the cockroaches when they first come in, but the first night they're there, they start coming out and what have you, because the place isn't fixed. It's just painted over and glossed over, just enough to get a tenant in there. Right. And then it makes it very, very difficult for them to do anything, because if they complain, then they're threatened with eviction, which is devastating, because even though the housing is substandard, they're not going to be attacked because they're not on the street. And so that was one class, a protected class that I saw, was people that were disabled. And I also saw families with children, right? Because once you establish yourself in an apartment complex and your children are in school, they have their friends, they have their community, they have their sporting events, all of these things, it makes it very hard for that person or that family to leave, because they have to uproot their entire family. And the third group that slumlords tend to go after are people that are not documented. So because they're fearful, they're not going to complain because they don't want authority. They don't want code enforcement to come to their house. They don't want any of that. And I used to, back in the day, before habitability was really a thing, there was wasn't really, 30 years ago, you didn't see a lot of habitability lawsuits. I was mostly housing discrimination, but I would, talk to these private, personal injury lawyers saying, is there something that we can do, right? Look at this, here's the law. But eventually then that developed into this habitability area of law that has become, actually, it's become bigger and bigger every year. I have more competition every year, which it's competition is healthy, so that's a good thing. But they do go after. It's the same. I feel like it's like the same story over and over again, that these poor folks who are have issues already, then they have on top of that, they have this building or this unit that's not being taken care of, and their voices are not being heard, or they're being threatened. So now I'm going to segue into the Tenant Protection Act, which has provided some help, but ironically, maybe not. I have a case here in Fresno where I filed a lawsuit. I think I have 15 or 17, mostly senior citizens, people on very fixed incomes, and the landlord gave them all 60-day notices, right? Because it's retaliatory to evict somebody because they exercised their housing rights. What they did was they said, let me back up. Actually, I should back up and explain the Tenant Protection Act. So the Tenant Protection Act was enacted in 2019. It took effect in 2020. And what it says is that certain buildings that are, certain 15 years, I think, or older, and you have to have good cause to evict that tenant, right? You can't just say, hey, here's your 30-day notice, you're out of here. So it does give tenants some protection that they didn't have in the past, right? Because in the past, a landlord could just say, unless you were in some sort of subsidized or rent control area, then the landlord had to have good cause to evict you. But in areas where there were not protection, then the landlord could come in and just give you a 30-day notice or a 60-day notice saying, we want you out. We're not going to tell you why. We just want you out. So the Tenant Protection Act is enacted, and now the tenant has, the landlord has to give good cause to evict the tenant. And so we thought, yay, that's a great thing, right? Because now these tenants are protected, and then it also has limits on rent, on how much the rent can be raised, and other protections for the tenant. And what has happened is some of these landlords have used that to their advantage, and they have said they're going to do substantial renovations, right? And that's why they're getting the tenants out. It's not because the tenant has exercised their rights. It's because they're going to do substantial renovations. And it was very frustrating for all of us in the housing business, I'm sure you as well, because these landlords would say, oh, I'm going to do a substantial renovation, which was not a substantial renovation. There were no permits pulled. There was no intent to do anything except for maybe replace the carpet or, paint the unit. So the Housing Rights Lobby approached the legislature and said, hey, this has to be, this can't be, because now these tenants are being ousted under the pretext of substantial renovation. So the law has actually changed that now in April, I think it takes effect, that they have to pull permits. But I had a property here in Fresno. I sued the landlord, and in retaliation, that landlord gave all the tenants 60-day notices, and then we were able to go in and get a restraining order so they couldn't enforce those 60-day notices. But the likelihood that a tenant's going to have that kind of resources to do that is not very great. So we're very grateful that now the law has changed, that now they require more proof than just we're going to do substantial renovations. And then there's penalties that are involved if the landlord lies about that. So very happy that there's teeth now, somewhat teeth. Be happier if there was attorney's fees for private actions in there.
There's not. Making it really difficult to enforce.
Right. So because there's private attorneys, it's hard to enforce that type of a statute, because you're not going to get paid for it. It's going to be for pro bono, which is great, but there's no penalty. So because attorney's fees are actually a penalty for the landlord. If the landlord does a bad thing, and then they get sued because they did a bad thing, and then they have to pay for the tenant's attorney, then that's certainly something that's going to hopefully dissuade them from doing that bad thing again. But unfortunately, there is no attorney's fees in the revised Tenant Protection Act,
which is too bad.
Yeah.
And makes me wonder, and we've talked about Tenant Protection Act a number of times on these broadcasts, it makes me wonder the seriousness of the state legislature and how on earth they were going to get this enforced. This seems like a great field area for legal aid groups, but I don't see anybody locally that's touching it with a 10-foot pole. Be that as it may, going back to folks who, when they do exercise their housing rights and make a complaint to code enforcement, or even to an attorney like Margaret Elder with Elder and Spencer, and they get an unlawful detainer, which is the lawsuit that is the prelude to an actual forced eviction. Can a tenant, when they do get served an unlawful detainer from one of these landlords, which is frequent, can that be an affirmative defense for them, that the landlord didn't fix anything? I mean, it doesn't seem like that works as an affirmative defense, because an unlawful detainer and the ability to remove somebody from your property kind of are different things, different points of law. Yeah. How does that work?
Well, so when you're in law school, you learn that the law favors the landlord, the landowner is favored, and it's no different, I think, when you go into an unlawful detainer court. In my experience, having defended a number of unlawful detainers, is the assumption is that the tenant did something wrong, walking right into the courtroom. 99% of, maybe not 99%, actually Central Valley has there's a lot of good organizations here that defend tenants and nonprofits, more so than I think in Los Angeles or other areas. But most of the time the tenant goes in unrepresented because they just don't know. It's a summary proceeding. you file the unlawful detainer. You can have your trial within 20 days if you do everything right. If you jump through all of the little hoops to get your day in court, which is difficult if you're not a trained legal person.
Right.
So, and tenants don't understand that or don't know that they have to file within 5 days. They have to all these deadlines that are fatal. If you miss that deadline, it's done. The landlord's going to take your default and you're going to be out. So if you're lucky enough to get your day in court, I've sat in court and watched pro pers come up and try to get their evidence in, and they're going up against a lawyer who is even though they have a perfectly great defense, the ceiling has collapsed. The city has written 15 notices of violation, and the landlord has refused to make those repairs unless they can get their evidence in front of the court. Then it's difficult for them. But yes, that is a defense. It's a viable defense. If the landlord has, and it's on the box, you can check the box on the answer to say that your unit is uninhabitable. So if you're doing that, my bit of advice would be get certified copies of the code enforcement report, right? Take photographs. Don't have it on your phone. Print them out. Show the judge, this is what my apartment looks like, Your Honor, and this is why I should not only not be evicted, but the landlord shouldn't be able to collect my rent until he fixes my unit, or at least a portion of my rent. So, and there are self-help groups out here and nonprofits, but it is exceedingly difficult for a tenant to defend themselves in an unlawful detainer.
Well, then, how do folks get in touch with you if you're a tenant and you're watching this and you have these kinds of problems? What is your advice? How do they get in touch with you? Do you have a website? Do you have a way for people to get in touch with you?
We do. We have a website. It's elderandspencer.com. We have a phone number, 559-317-1008. You can also email us at info@elderspencer.com. We have a bilingual staff that will take down information. We'll review it. We will get back to you and let you know if it's a case that we think we can help you on, or if we can't help you, then we also have resources that we give to potential clients if their case is not ripe for a lawsuit or doesn't not something that is catastrophic enough to file a lawsuit. Then we have resources, information that we give out to tenants to direct them to the right agency, nonprofit, whoever can help them with their problem. My one bit of advice before I go is, if you didn't write it down, it didn't happen. So
keep good records.
When you tell your landlord that you have cockroaches, when you tell your landlord your toilet has spewing sewage all over your apartment, write it down. I tell my clients to get a little calendar. Go to the 99-cent store, get a little calendar, write it down. On this day, this happened. And because the landlord is never going to say, yeah, they told me that their place was, messed up, and I didn't fix it.
No, they always say, I didn't know, they didn't tell me. That's been my experience. Well, thank you once again for watching us here at Fair Housing It's the Law, and I want to thank Margaret Elder of Elder and Spencer for telling us all about it in terms of slumlords. Thank you.
Thank you.